Hi, this is Mike again. Today I wanted to talk about how Section 3 of the 14th Amendment is being proposed as a means to take down Donald Trump and prevent him from holding the office of president again. This is another way that the left is trying to eliminate Trump from the presidential landscape. This idea was first proposed by two so-called conservative scholars who did the research and review of Trump's actions during the so-called January 6th insurrection, which they say prevents Trump from running for office again. The names of the two authors are William Baude and Michael Paulsen. William Baude is a professor of law and institute at the University of Chicago Law School, where he teaches federal courts, constitutional law, and conflict of laws. His current research interests include the 14th Amendment, particularly both Section 1 and Section 3, and the nature of judicial discretion. Professor Baude received his B.S. in mathematics from the University of Chicago and his J.D. from Yale Law School. He then clerked for then-Judge Michael McConnell on the United States Court of Appeals, and Chief Justice John Roberts on the United States Supreme Court. Before joining the Chicago faculty, he was a fellow at the Stanford Constitutional Law Center, and a lawyer in Washington, D.C. The other author is Michael Paulsen. Paulsen received his B.A. degree with distinction from Northwestern University, where he was a member of Phi Beta Kappa. He received an M.A. degree in religion from Yale Divinity School and a J.D. degree from Yale Law School, where he was an editor of the Yale Law Journal and a recipient of the Harlan Fiske Stone Prize for Appellate Advocacy. After graduation from law school, he joined the Department of Justice in the Criminal Division Honors Program and has also served as staff counsel for the Center for Law Religious Freedom in Washington, D.C. and as an attorney advisor in the Office of Legal Counsel. Prior to coming to the University of St. Thomas School of Law, Paulsen served as the McKnight Presidential Professor of Law and Public Policy, Briggs & Morgan Professor of Law, and Associate Dean for Research and Scholarship at the University of Minnesota Law School. Professor Paulsen is among the nation's leading scholars of constitutional interpretation, and his publications include articles in the Yale Law Journal, Stanford Law Review, Chicago Law Review, NYU Law Review, Texas Law Review, California Law Review, and the Georgetown Law Journal, among many others. According to their analysis of the events of January 6, Trump participated in an insurrection on that date. They judged the events of January 6 under the standard of Section 3, and according to them, it is unquestionably fair to say that Trump engaged in the January 6 insurrection through both his actions and his inaction. Officials, administrators, courts, and legislators, whose responsibilities call upon them to apply Section 3 properly and lawfully must take action within their powers to preclude Trump from holding future office. Moreover, if one accepts as they do, the broader argument that the entire campaign to overthrow the results of the 2020 election was a form of constitutional rebellion, then Trump's complicity is even more obvious. Secondly, Trump is seen by them as the leader, motivating force, and chief attempted perpetrator of that rebellion. Indeed, according to them, it would not be going too far to say that Trump, having previously sworn a constitutionally required oath to preserve, protect, and defend the Constitution of the United States, knowingly attempted to execute what, had it succeeded, would have amounted to a political coup d'état. Third, they also see that his actions against the Constitution and its system of elections were meant to overturn the results of the election in order to maintain himself in office as president. If that action itself constitutes rebellion against the Constitution, Trump's overall course of conduct disqualifies him under Section 3, even apart from the specific incitement to storm the Capitol. So what does Section 3 of the 14th Amendment say? It says that no person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States, or under any state, who, having previously taken an oath, as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. The one exception is that Congress may, by a vote of 2/3 of each house, remove such disability. So what is the background regarding this section of the 14th Amendment? This section of the 14th Amendment was designed to address a particular historical situation and acute problem arising in the aftermath of the Civil War. States in the South had purported, unconstitutionally, to secede from the Union. They had purported to form the Confederate States of America in rebellion against the authority of the U.S. Constitution, and they had waged a bloody 4-year war of rebellion against the United States. Yet even after the rebellion had been defeated, Southern states had audaciously sent to Congress, to serve as U.S. senators and representatives, men who had notoriously violated previously sworn oaths to support the U.S. Constitution by subsequently engaging in or supporting secession, rebellion, and civil war against the authority of the United States, to say nothing of those now serving again in their state governments. These men who arrived in Washington included several who had held prominent positions in the rebel Confederacy. It included 4 Confederate generals, 4 colonels, several Confederate congressmen and members of Confederate state legislatures, and even the Vice President of the Confederacy, Alexander Stephens. The Congress that proposed the 14th Amendment rightly regarded the situation as outrageous, not only morally, but practically. If former Confederates held the levers of federal and state government power, effective reconstruction of the political order and any hope of extending the full and equal protection of the laws to the newly freed former slaves would be at an end. Section 3 of the 14th Amendment responded to that outrage, enacting a sweeping disqualification from state and federal office of those who had, as legislators or officers in the federal or state government prior to the war, sworn required oaths of loyalty to the United States Constitution and subsequently engaged in insurrection or rebellion against the U.S. constitutional authority or given aid or comfort to persons engaged in such acts of insurrection or rebellion. Only a 2/3 majority vote of both houses of Congress could remove that sweeping disqualification. Fast forward to today, the events surrounding efforts to overturn the result of the presidential election of 2020 have sparked renewed scholarly, judicial, and political interest in Section 3 of the 14th Amendment. The researchers claim that the core events are familiar to all: the dishonest attempts to set aside valid state election results with false claims of voter fraud. Trump's purported attempt to subvert the constitutional processes for state selection of electors for president and vice president. His efforts to have the vice president unconstitutionally claim a power to refuse to count electoral votes certified and submitted by several states. Also, the efforts of members of Congress to assert a similar power to reject votes lawfully cast by these same electors. Trump's action to foment and incite a mob to attempt to forcibly prevent Congress's and the vice president's counting of such lawfully casted votes, all in an attempt to prevent the defeated incumbent president, Donald Trump, from losing power in accordance with the Constitution. They see this as an undoubtedly serious assault on the American constitutional order. Not since the Civil War has there been so serious a threat to the foundations of the American constitutional republic. They said that it takes little imagination to describe the efforts to maintain Trump in office, notwithstanding his defeat, as an attempted political coup d'état. According to them, these actions culminated in the incitement and execution of a violent uprising at the Capitol on January 6, 2021. An insurrection aimed at preventing Congress and the incumbent vice president from performing their constitutional responsibilities to count the votes for president and vice president in the 2020 election. Several of the people involved in these events, most notably the defeated president, Donald Trump, had previously taken oaths to support the Constitution. If they engaged in or gave aid and comfort to an insurrection against the constitutional government, Section 3 would appear to bar them from holding office again. However, the key question was, did he give aid and comfort to the insurrection? This same president was the one who offered to have the National Guard available to prevent any problems that may result. However, his offer was turned down by Nancy Pelosi, the House leader. Think about it. Would someone who was supporting an insurrection have offered troops to prevent any problems? It seems that it would be more appropriate that the House leader and any other senators who supported turning down Donald Trump's offer should be charged. It was their action that allowed this so-called insurrection to happen. The other question we need to ask is, was this really an insurrection? If you look at many of the videos from January 6th, it looked like most of the people were quite civil as they calmly strolled through the House chambers. It was only the action of a few that made this event more violent than it was. In many cases, the leaders of these violent actions were never charged. One should ask, why is this? If it was so violent, why were not the most violent leaders arraigned and charged? One could also argue that the insurrection was aided by a number of members of the FBI or other federal agencies who were active in initiating this so-called insurrection. Many of these people would also have taken oaths to the Constitution. Will they also suffer this proposed fate as well? Or like many of the other issues and legal suits against Donald Trump, will his opponents get off scot-free? Certainly, the key questions in this whole discussion are, 1. Was this really an insurrection event? 2. If it was, what actions did Trump take to support or cause it? 3. If it was an insurrection, why were some of the obvious leaders of the event never charged? Certainly, the facts that have come out so far do not support that this was an insurrection event supported by Trump. If there was such an event, who were the real parties behind it? I believe that until some of the violent leaders of the event are identified and arrested, we will never know. Was this event really the result of the deep state who wanted to take down Trump and his America First supporters? We believe it was, so this is another example of a manufactured crisis for the sole purpose of preventing Donald Trump from ever holding office again. Thank you for listening to my discussion regarding the issues behind the use of Section 3 of the 14th Amendment being used by the left to prevent Trump from holding office again. To learn more about other cultural issues, please go to the Nehemiah Reset website at Nehemiah Reset.